Hi, this is Scott Theobald from Gordon and Reese, and I'm going to share a couple of quick tips with regard to the sale of e-commerce businesses. I'm a partner in Gordon and Reese's corporate transactions group and the e-commerce group, and have 30 plus years of experience buying and selling companies, including e-commerce companies. And the three tips I'm going to share, the three things that I think would be good for you to know on a quick basis, relate to brokerage agreements, corporate housekeeping, and website online terms and conditions. So with regard to brokers, you're going to probably want to hire a broker to sell your company if it's of any significant size. And in connection with doing that, you're going to want to pick a broker that has an established track record of success in selling e-commerce businesses, someone that is going to prepare a confidential information memorandum, sometimes called a pitch book, to present to buyers that will help them become informed about what your company offers and about the financial and legal characteristics of your company. They're going to assist you in negotiating the deal, and they're going to help close the deal. And in exchange for that, they're going to ask you to sign a brokerage agreement. That brokerage agreement is going to have two important periods in it. One is an exclusivity period, and the other is the tail period. The exclusivity period deals with the period of time that usually is somewhere between 6 months and a year. Sometimes brokers try to make it longer than that, but you want it to be on the shorter end of things. That period is when the broker has an exclusive arrangement with you to act exclusively to sell your company. And the tail period is the period that follows that exclusive period. And that's following the termination of the agreement. If the company sells during the tail period, the broker is still going to expect to be paid all or some significant portion of the fee that the broker would earn if it's sold during the exclusive period. Fees range, they vary widely. I've seen fees on the total enterprise value of the company that's sold vary anywhere from as little as 1% at the very low end of the scale to as high as 12% at the very high end of the scale. Fees are highly negotiable, and you want to definitely negotiate fees with the broker. Brokers also frequently ask for a monthly retainer, which is some dollar amount that's used to offset their overhead expenses that they incur during the time that they're working on the sale of your company. Okay, let's talk briefly about corporate housekeeping issues. The due diligence process in general is what occurs when a buyer is investigating your company and trying to determine whether to actually follow through on the purchase. So the buyer will be looking at all of your corporate documentation and financial results. It's very important to have all of these documents lined up and organized and make sure they're all signed well in advance of when the buyer begins asking for them. The buyer's undoubtedly going to ask for historical financial records, financial analyses of your company, tax documents, debt and financing documents, and financial projections for what you expect going forward. On the legal front, the buyer is going to want to see the documents that are sometimes called the organizational documents of your company, the articles of organization, the articles of incorporation if it's a corporation, or organization if it's an LLC, shareholder agreement or any agreement between all of the owners of the company, operating agreement if it's an LLC, if there are any options or warrants outstanding for the purchase of additional equity, the buyers are going to certainly want to see those. And a very important document is the cap table, capitalization table, that shows how the equity, the ownership of the company, is allocated among the various owners of the company. If it's an LLC, it will show who owns what membership interests in the company. If it's a corporation, it will show who owns and how much they own, common stock, preferred stock, different series of preferred stock, etc. On the intellectual property front, you're going to want to be able to show them copies of trademarks, copyrights, patents, license agreements, etc. And if your company's ever been involved in litigation, you're going to need to present the litigation documents to them so that they can understand what litigation is currently pending and what risk they might be assuming by buying your company. Lastly, let me mention website disclosures. If you conduct business online, you want to have in place, well in advance of having a buyer starting to look at these things, a click wrap contract that is signed by every single user of your website that has a box where the user clicks, I agree to the online terms and conditions. The online terms and conditions on your website should include a mandatory arbitration provision and should also include a class action waiver. Those things will protect your company and will be very helpful to you in the long run in terms of making your company safe or safer from certain kinds of risks. I hope you found these tips helpful, and I wish you the best of success in selling your e-commerce business.